Hi, everyone. Harry here to talk about a really strange order filed by the administration in the District of Maryland, the Federal District Court, against all the judges in the District of Maryland and attacking an order that the chief judge of the District of Maryland entered saying, if we get a habeas petition from one of these deportees, this is the district, for example, where Abrego Garcia has filed a petition, no deporting for a couple days. That's, we're entering this minimum time that at least we're going to be able to give it some minimal consideration. Okay. The administration sees this as their inroad to do what they've been trying to do generally, which is attack these broad injunctions that have been entered again and again and again. They point out in their papers more times in the Trump administration than in the 100 years or whatever before. And of course, that's because the Trump administration has been nothing but a lawless skein of unlawful executive orders that have resulted in a stunning series of reversals in May. 26 of 27 go against them. So they just again and again and again test the law, and the courts have, especially district courts, have been pretty strong in responding. Okay. But that's the very thing they want to get at. They want to attack these kinds of overall injunctions that district courts all over the country are entering, and they're trying to use this as the whipping child. Why? Well, the 2-day standing order, that is portrayed here as a complete and outrageous derogation of executive authority. And why is that? Well, says the administration, it robs the administration of the most important resource that it has to carry out executive policy: time. So having to wait 48 hours absent any kind of specific case and specific jurisdiction, but just as a standing order, that's a terrible robbery of the executive branch of time. Okay, so what is going on with the weird form of this suit? So this has to do with the difference about the equitable laws and equitable remedies of a court as opposed to suits under particular statutes. And because of the way things worked in equity, by which we mean, the hundreds of years before in England and the like, when certain kinds of orders were entered by a judge, the suit saying freeze these orders or reverse these orders, it's directed to the judge personally. You've seen some things like this in the New York courts where cases actually go up on appeal technically against the judge who issued them, and that judge has counsel to represent them in the appellate division and the like. So it's the same thing here. They're looking for an equitable order. It's a little hard to see how it even would apply or who would grant it. An equitable order extending, well, I guess for now, what they hope is an equitable order entered by the Maryland courts or the courts above Maryland or the Supreme Court. But they're looking to somehow do an attack that is broad gauged against the very sort of mechanism that the courts have employed again and again and again, and is what you do employ when the executive has undertaken lawless action, these kinds of preliminary injunctions and stays and the like. And another part of the weird procedure here is we've seen this again, it's always a little confusing, but when district courts enter a certain form of preliminary relief, courts of appeals aren't supposed to disturb that. So until it goes to a preliminary injunction, what we've seen courts of appeals do is actually construe some of those orders as preliminary injunctions. That you don't have to worry about. That's a very kind of confusing and in the weeds civil procedure notion. But the idea is the U.S. is proceeding in equity, and therefore technically, nominally, not in any way will the judges have to pay money or surrender their robes or whatever, but to get this kind of equitable order that says, stop doing this, judges, at least in Maryland, that's a suit in equity. So it's a very unusual form of suit. I think it's not very likely to proceed, but, it's making this claim, oh no, 48 hours having to wait as a general matter. That's a terrible imposition on us. And you can imagine a court biting on that proposition. It's not a terrible imposition, but you can say, well, there could be instances where they want to move more quickly. Anyway, that's the lawsuit that is now teed up, and it is in equity, and that makes it against the judges. But the relief they want is sort of general and going forward, and a kind of declaratory judgment of certain kinds of orders, and that seems pretty remote to me. And this is at least in part to try to push back in the same way they're doing in the Big Beautiful Bill, have some defense against what is really completely justified, a series of injunctions entered because of lawsuits initiated because of lawless executive orders, which really is the stock and trade of this entire administration. And, if they are galled by that, one mild suggestion might be to stop introducing so many unlawful executive orders. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.